Hello, and welcome to our PowerPoint about patents. My name is Connor, and today I'll be discussing this with Felix and Tony. A patent is a legal document issued by the federal government that provides legal protection for an idea. A patent also gives a monopoly to the creator of an invention and grants exclusive rights to his or her creation. Felix will now discuss the origins of how patents came into existence.
Just like copyright, the law of patents is entirely based upon statute, however differing entirely from copyright at the same time. While copyright comes into existence automatically upon creation of the work, most of the cases, a patent exists only after a grant from the appropriate government body, which is the Government of Canada Intellectual Property Office in case of the Canadians. The first Federal Patent Act, in 1869, largely based upon the existing American legislation rather than British or European models. This was pretty obvious because Canada is really closer to United States than Britain itself. Canada's current Patent Act substantially amended in 1987. Further substantial amendments were introduced in 1992 and 1993. Patents granted or applied for prior to the dates remain subject to the earlier law. Main cause of the amendments was due to the inventions such as bromine extracts, calcium carbonate for acetylene. Anyhow, due to the medical improvements and inventions of new medical supplies and pharmaceutical products, substantial amendments were introduced. The results made distinguishable difference between Canadian patent law and US, British, and European rules. The Patent Act defines an invention as any new and useful art, process, machine, manufacture, or composition of matter, which is in Section 2. A patent will not be issued solely for scientific principle or abstract theorem, such as mathematical formula, Section 27 at 8. For these purposes, a computer program is equated to an abstract theorem and is not by itself patentable. In order to be registered as patent, Government of Canada Intellectual Property Office defines those as novelty, first in the world, in other words new, utility, functional and operative, in other words useful, ingenuity, showing ingenuity and not obvious to someone of average skill who works in the field of your invention, which is inventive. An invention can be a product, for example door locks, composition, chemical compositions using lubricants for door locks, a machine for making door locks, a process, a method for making door locks, an improvement of any of these that I've mentioned above. And now I shall pass this on to Tony, who will be explaining on how to obtain a patent and its processes.
Hi, this is Tony, and I'm going to talk about the process of obtaining a patent. The inventor and legal representative may apply for a patent, and the employer usually owns inventions made by its employees and is rightful applicant. The applications are made to the Commissioner of Patents and then processed by the Patent Office. Individual inventors or patent agents may pursue their own application. Before the individual or the patent agent started making an application, they will first search online or at the U.S. Patent Office in order to make sure there is no patent has been granted in respect of invention. Then they will start to draft the application. There are two elements that are very important in an application, and these are specification and a claim. A specification is the description of the invention, its use, operation, or manufacture. A claim is a statement of features claimed to be new and in respect of which the applicant claims an exclusive right. When the application is completed, they file the application and meanwhile make a further application for the claim to be examined. Then an examiner considers the application. The applicant can make change to the application once while the examiner go over the specification and the claim. Finally, examiner made a decision either when the application is approved, a notice of allowance will be issued, and a payment of the fee is issued. When the application was rejected, appeal form rejection may be made to the Patent Appeal Board and then to the court.
After obtaining a patent, there are a few rights and rules you have as an owner. Patents last only 20 years. This day starts when the first day of registration happens, and after that your ideas are open to the public. Also, a yearly fee must be paid for the ownership of your patent. As the owner of the patent, it is up to you to decide how your invention is to be used. You may sell it, you can assign the patent rights to others, or you can do nothing with it. The choice is up to you because you own the exclusive rights. Industrial design is a piece of legislation also known as the Industrial Design Act. Its job is to protect products with visual distinctions, recognizable features, shapes, configuration, or patterns considered identifiable and original. The design itself must be considered inventive. Examples of this include products like Apple's iPhone or the Fender Stratocaster. Both are easily recognizable to the average person because of its unique shape. Rights on industrial design only last 5 years. Thank you for listening and have a great day.